Good morning. It is 9 a.m. on October 14th. This is a special docket that was created to handle contested cases, but we are taking some overflow for some cases that need a little help. We have an AI transcript that will be generated at the end of this, and the YouTube video will be posted, which is the public record. Let's get on with the cases. Case one on my docket is 25515 Mewbourne Oil Company. Entries of appearance, please. If anyone's speaking, I can't hear you.
It looks like Miss Vance might be talking, but she's muted if she is.
I do see that. Thank you, Mr. McClure.
Okay, I can hear. I don't know. I can finally hear. I'm not sure if you already called my cases, Mr. Shakalian. Sorry.
Okay, I'll start again. This is case number one on our docket, 25515.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Mewbourne Oil Company.
It also looks like these are joined to cases 16, 17, and 18.
That's correct.
Please, are there any other parties entering on these cases?
No.
Okay, please proceed.
Thank you, Mr. Hearing Examiner. And I will let you know that we filed revised hearing packets. I got an email from Mr. Fordyce. I believe it was on Friday last week, providing for the corrected pool name and pool code for these. So I did file an amended pre-hearing statement that listed the correct pool name, pool code, and then also I included on those revised hearing packets a cover page that lists the different documents in the hearing packets that were updated because of the revised hearing pool name and pool code. So should be the compulsory pooling checklist, the landman statement, and the C-102s. Also, Mr. Fordyce did ask at the last hearing, because we presented case 25515, that the sub-exhibit D2 be updated to show the specific spacing unit per that case. And so we went ahead and did that for each of the sub-exhibits D2 for all of the cases, since we were doing revised hearing packets anyway. So again, we filed those yesterday, and I did send an email to Mr. Fordyce, though it looks like Mr. McClure might be the technical examiner today. So I just wanted to bring that up in case there's any questions on that. So, and I will, one other item, our original landman, he's not available today. So we did substitute in Mr. Tyler Jolly. He has previously testified before the division, and his credentials have been accepted as a matter of record. So in all four of these cases, it involves lands in Township 24 South, Range 28 East, and that's in Eddy County, New Mexico. All of them are Bone Spring formation. So specifically in case number 25515, Mewbourne is seeking to pool the uncommitted interest in a 320-acre, more or less, horizontal well spacing unit. And that's underlying the west half of the east half of sections 16 and 21. And the pool name is the Malaga Bone Spring, and the pool code is 42780. And initially dedicate this spacing unit to the Credence 2116 Federal Com 556H well. And then in case number 25516, Mewbourne is seeking to pool the uncommitted interest in a 320-acre, more or less, well spacing unit, horizontal well spacing unit, underlying the east half of the east half of sections 16 and 21. And again, it's that same Malaga Bone Spring pool, and the pool code again is 42780. And initially dedicate the spacing unit to the Credence 2116 Federal Com 558H. And then in case number 25517, Mewburn is seeking approval of an overlapping horizontal well spacing unit. You'll see in both this case and in case 25518, we've included a copy of the letter notice that went out regarding the overlap and a diagram that illustrates the proposed spacing unit in relation to the existing spacing unit. And in both of those cases, it's sub-exhibit C1. In case number 25517, Mewburn is seeking to pool the uncommitted interests in the west half of the east half of sections 28 and 33. And in this case, the pool name is Willow Lake Bone Spring, and the pool code is 64450. And initially dedicate this spacing unit to the Kansas 2833 FedCom 556H. And then in case number 25518, again, requesting that overlapping approval, and Mewburn seeks to pool the uncommitted interests in a standard 320 acre or more or less horizontal well spacing unit, and that's in the east half of sections 28 and 33. And again, it's that same Willow Lake Bone Spring pool code 64450, and initially dedicate this spacing unit to the Kansas 2833 Federal Com 558H well. We have included a copy of the filed application in each of the hearing packets, along with the compulsory pooling checklists. Again, those have been updated accordingly. And then we have the self-affirmed statement of Landman Tyler Jolly. Again, he has previously testified, along with all the required Landman sub-exhibits. Following that is the geology. Our geologist, Tyler Hill, has previously testified, and his credentials have been accepted as a matter of record. And we've included all of the required sub-exhibits for geology. And then following that is my self-affirmed statement of notice with a sample copy of the letter notice. There were a couple that went out. One on July 18th, 2025, and then a second letter that went out on September 10th, 2025. And I believe it's in the Kansas cases. There's only one party that we're seeking to pool, and that letter notice was delivered, and it shows it in the mailing report. So I did not attach the notice of publication because we don't need to rely on it. Either way, in the first two Credence cases, we did include a copy of the notice of publication, and those were timely published on July 19th, 2025, and then also a secondary one that was published on September 20th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Without objection. I think it's Mr. McClure. Mr. McClure, are you the technical examiner for these cases?
Mr. Hearing Examiner, I believe it's
Mr.
Mr. Fordyce.
Thank you.
Yeah, I'm here, Mr. Hearing Examiner.
Wonderful. Thank you, Mr. Fordyce. Do you have any questions on these four cases?
No, I reviewed the amended exhibits filed this morning with corrections to the pool codes and the requested correction to Exhibit E2. They all look good. I don't have any further questions for these four cases.
May they be taken under advisement?
They can be taken under advisement.
Excellent. Thank you, Ms. Vance. Let's move on to number 5 on our docket.
I still can't hear Mr. Shakalian.
Okay, we're off the record in the first four cases, so let's move on to case number 5 on our docket, 25519, Oxy USA.
And this is one of Miss
I can't
Vance's
hear
cases.
anything. I'm not sure if that's a me. I just heard Mr. Fordyce, but I cannot hear Mr. Shakalian.
Freya, are we having technical difficulties?
We aren't on our end
Okay.
that I can tell, and we're not in the hearing room, so we don't have the issue of the room being muted.
I can hear you, Freya, but I could not hear Mr. Shakalian when he was just talking.
Okay, Freya, would you tell Ms. Vance that I've called case number 5, Oxy USA?
Can other people hear him?
We can all hear him. He did call your case on number 5. Do you want to log off and log
Can anyone
back
else
on?
hear Mr. Shakalian talking? I cannot hear him talking. I can hear Dean right now. I can hear Freya. I can't hear Mr. Shakalian.
Miss Vance, can you log off and then log back in?
Okay, let's go on. We'll come back to number 5 in a few minutes. Let's move on to XTO Energy. This is case number 25577. Entries of appearance, please.
Understand?
We might
Can
wanna
people
call
hear me? I can't,
number
like,
11.
I don't know what's going on. Can
Oh, we can
anyone
hear
hear
you.
me? Can somebody
Yeah, I'll-
respond?
We can
Oh,
all
we can
hear
hear you.
you. Can you log off and then log back on?
Freya?
It looks like Miss Vance is logging off and we'll try and log back in. We can
This
move
case-
to number 11.
Okay, let's move to number 11. Excellent. Okay, I'm going to call case number 25615. This is Mewbourne Oil Company.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Mewbourne Oil Company.
Good morning. Are there other parties that have appeared in this case, Ms. Hardy?
Yes, I believe Ms. Bennett represents Paloma.
Yeah, and I don't think we've made that decision.
Who's speaking?
Good morning, this is Dina Bennett. Sorry, I'm having some technological issues as well this morning, but I'm here on behalf of Paloma Permian.
Have you entered an appearance?
Yes, I entered an appearance in these cases.
What is your position in this case?
We were only monitoring and
Perfect.
preserving rights.
Thank you. Ms. Hardy, go ahead.
Thank you. And Mr. Examiner, we did present this case last week, but Mr. Fordyce had requested an updated C-102 that shows the first take point within the spacing unit. And then also on Friday, we received an email requesting that the pool name and code be changed. So we did submit our supplemental exhibits making those changes, and I would request that they be admitted and that the case be taken under advisement.
Thank you, Ms. Hardy. Without objection, Mr. Fordyce?
Yes, Mr. Hearing Examiner, I reviewed these amended exhibits this morning as well, with the corrections to the pool code and to, Exhibit A2, the C-102, everything looked good. No further questions. This case can be taken under advisement.
Excellent. Thank you, Ms. Hardy. We're off the record.
Thank you.
Let's move on to case number 12. This is Tascosa Energy Partners, 25619. Entries, please.
Dana Hardy on behalf of Tascosa Energy Partners, and there are no other parties.
Perfect. Thank you. Go ahead.
We presented this case last week as well, Mr. Examiner, and there was a request that we submit updated geology exhibits that showed the correct location of the spacing unit. So we did that on Friday, and I would ask that the exhibits be admitted and that the case be taken under advisement.
Without objection, Mr. Fordyce?
Yes, I reviewed these as well, Mr. Hearing Examiner. The corrections I requested have been made. I have no further questions. The case can be taken under advisement.
Thank you, Ms. Hardy. We're off the record in this case. Let's move on to I probably should ask Freya, what's the next case that Ms. Vance is not involved with?
Line 15, Spur Energy.
Perfect. Thank you. I'm calling case 25632, Spur Energy Partners.
Good morning, Mr. Hearing Examiner. This is Yaditza Pena with Hardy McLean on behalf of Spur Energy Partners.
Are there any other parties that you know of?
Not that I'm aware of.
Go right ahead.
So we also previously presented this case on Thursday, and we're coming back with an amended exhibit packet that we filed, correcting the pool code and pool name that Mr. Fordyce had given us on Friday, and also an amended C-102 with the kickoff point filled in as he requested on Thursday at the hearing. So with that, I would ask that the case be taken under advisement with the amended exhibit packet.
Without objection, Mr. Fordyce?
Yes, Mr. Hearing Examiner, I reviewed this amended exhibit packet filed with corrections to the pool code in Exhibit A2, the C-102s. I have no further questions. This case can be taken under advisement.
Fantastic. We're off the record in this case. Freya,
Thank
the next
you.
case?
Yes, lines 2021 WPX Energy. Cases 256.
Okay. Okay, thank you.
256.
Perfect, thank you. I'm calling WPX Energy, case numbers 25611 and 25612. Entries, please.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Aberdeen Shell appearing on behalf of WPX Energy Permian LLC.
Are there other parties, Mr. Savage?
No, there are not.
Go right ahead.
So again, this case was heard on last Thursday, October 9th. We moved it to today to address amended hearing packets. We filed the amended hearing packets. We gave a cover letter that describes what we changed. And at this time, I'd ask that the amended hearing packets be admitted into the record.
Thank you. Without objection. Who is the technical examiner for these two?
Mr. Fordyce.
Mr. Fordyce, any questions?
Mr. Hearing Examiner, yeah, same with these. I reviewed the amended exhibits filed this morning with corrections to the Exhibit A1, the C-102s, and Exhibit B1. I have no further questions. These two cases can be taken under advisement.
Perfect. Thank you. We're off the record
Thank
in these
you.
cases. Freya, the next cases?
We have the contested hearing cases next, so I think we need to go back to Ms. Vance's cases.
Around?
I'm sorry?
Is she around?
I'm here.
Okay, I
We can
can't
hear
tell.
you.
Your camera's off.
It should be on. I
It
can
is
see
now.
me.
It is now, Ms. Vance. Okay, we've just so you can catch up here. Cases 1 through 4 were taken under advisement. We're going on to case number 5. This is your Oxy USA case, 25519.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Oxy. And we're here. This is a continuation of this hearing. So we filed some supplemental exhibits, and I believe give me 1 second. I had to
Ms.
restart
Vance, before you continue, are there any other parties in this case?
Yes, EOG made an appearance, but there are no objections. I'm not sure if Miss
That's okay. Go ahead, Ms. Vance. It's fine.
Okay, so we did file, and I think you may be aware, because I did talk with Mr. McClure regarding this case. So we filed our supplemental exhibits. However, one of the things that we did notice in the application is that we need to file an amended application and then redo the notice to correct the legal land description. It doesn't change any of the exhibits or the exhibit A that was included. It's just a matter of correcting the legal description for the project area. We have that amended application. We're going to file it today. And again, I've already talked with Mr. McClure about the proposed path forward. And we would just ask that that Oxy can file that amended application. We'll complete the notice, and we'd like to come back for the November 13th docket and perfect notice at that time.
Okay, are you asking me to admit anything into evidence before I turn to Mr. McClure?
Yes, please. So we did file a supplemental exhibit last Thursday. And so that basically goes through, we've included a draft exhibit A and B, gun barrel views, a type log for the requested for the pics Mr. McClure asked for, and then a 2-mile surface ownership map. And so I would request that those supplementals be accepted into the record.
Okay, without objection. Mr. McClure, do you have questions in this case?
Yes, I do, Mr. Hearing Examiner. For Ms. Vance, though, just talking about what she just referenced on the exhibit packets.
Perfect, go right ahead.
Thank you, Mr. Hearing Examiner. Ms. Vance, you referenced that there's not going to be a change to exhibit packet. Did I hear you correctly there?
There should not be, because everything, I believe, it's just the project area that needs to be amended in the application itself. But I don't believe that changes any of the exhibits, unless unless you're seeing something different. But my understanding is that would not change the exhibit A that we included with the original application.
Okay, I didn't, I guess, look through the exhibit packet, looking to see if the project area is ever referenced there. Are you stating that the project area is not referenced, or else it is the correct project area within the exhibit packet?
It's the correct project area in the exhibit A, but I'm happy to double check that before, we file anything today. But it shouldn't change anything, because the C-102s that are included with the exhibit A show the full legal land description, or show the full dedicated spacing unit that we need to just then update in the filed amended application.
Now, in providing us with the new notice information for the amended application, is it your intent to include that as supplemental rather than adding that to your exhibit packet, I guess?
I'm not sure that I follow what you're asking. Can you maybe re-ask that?
Yeah, it's your intent to provide new notice of an amended application. Is that correct?
Correct.
And what is your intent for providing the notice information to the division for that new notice?
So one of the things that I did is in the letter notice, I clearly made a note calling out the reason for the amended application, and also drawing attention to the correction in the legal land description for the project area in the letter notice, and then where it's also indicated in the amended application. And so I would just propose filing a copy of the notice, to show a copy of the notice for the November 13th docket, to show that we provided that a copy of the amended application, and provided notice to affected parties on the correction that was made to the project area, correcting that legal land description.
Okay, I guess just so I understand what we currently have on record, would it be accurate to say that we currently have an application, then we have an exhibit packet that builds off that application, and now we also have a supplemental exhibit packet? Is that correct?
Correct.
So it's your intent to include the notice information with the amended application packet. Is that then correct?
Can you ask that one more time? You mean just the
Okay, yeah, you're going to give us a new notice spreadsheet and then a new notice of publication, presumably.
Yeah.
How are you providing that to us?
filing it? And I can do it as a supplemental.
In a new supplemental exhibit packet is what you're proposing.
Yes. I'm not sure why it's funny, but yes.
Well, I wasn't sure what your response was initially. I wasn't understanding you. But now I'm understanding you. I guess, Mr. Hearing Examiner, is it your thoughts that we should try to combine some of these packets, or
Yes,
what are
I
your
mean,
thoughts there?
whatever would reduce the confusion caused by so many different filings would be helpful. Yes.
I was gonna say, I believe the reason that they have their application separated from their exhibit packet is due to page count, I believe was their reasoning initially.
That's correct. So it's just because it's such a large exhibit A, we have to send it piecemeal to Freya to upload because we can't do it by filing it through the e-permitting webpage.
Is that due to file size limits?
That's correct. It's too large of a file. I am happy to combine everything, but then just break it down and send it to Freya to do either an amended or supplemental. I can add everything that we have filed at this point in terms of the that we have previously done as a hearing packet and just combine it together with this supplemental amended application and then notice. If that would be better. And then again, I'm happy to follow up with the technical examiner to send you a copy. I can do that through a share link. That way you know it's been filed.
I know that's providing us exhibit packets via an email is definitely not the ideal solution, I guess, and having us manually upload. Are these file sizes larger than 100 megabytes? Is that what the issue is?
That's my understanding. I don't do the filing. I have a legal assistant who does that, and she coordinates with Freya when the file sizes are too big, and we can't do it through the e-permitting portal system or the imaging system. So, yeah.
Mr. Hearing Examiner, I almost wonder if maybe it's a concept that we should have like a part 1 of 2 and a part 2 of 2 and have them submit it through the portal separately that route. As to whether we submit it as an application and then the exhibits or whatever we want to do there, though, I don't know what your thoughts are.
Whatever works for Ms. Vance and you, I'm here to facilitate it through the hearing bureau. So I also wonder about the size of this exhibit. I wonder, Ms. Vance, if you might explore, or your assistant might explore, converting it to a different file type, because many times what's very large in one file type, like a JPEG or a TIFF file, is much smaller as a PDF. And I think I would encourage you to have someone explore that. So anyway, that being said, Mr. McClure, where do you want to go from here?
Allow them to conduct new notice, continue it till notice can be cured, and get us, I mean, at this point, it might be easier just to submit a whole new bundle of amended exhibits, and however we deviate that out to meet the 100 megabyte size limitation. I know what we currently have there doesn't look like it's even coming close, though. Like the application looks like it's 28 megabytes, and that's the biggest of everything currently in the case file.
One of the things I did do with filing the hearing packet was, rather than filing the full application that included the exhibit A, I have a cover page that refers to see the application for the exhibit A. Because it is so large and we had to break it up. So, I mean, filing the hearing packet is shouldn't be, such a big deal, but it's just a matter of how you'd like that filed. I'm happy to, again, just prepare an amended hearing packet that includes all of the new notice and a copy of the revised or the amended application, and then just let Freya know so she can swap it out with what was previously filed, so there's no confusion, or however you would like to do it.
I will say, in regardless to what we do in the case file, I think we need to submit a new submission rather than trying to swap out for the prior submission, if that makes sense.
Yes,
Okay, and my thought process is just attempt to put it in a single submission, and then if you run into file size limits, then we can go down the route of breaking it up.
that works for
Yeah.
me.
Okay.
Is there anything further, Mr. McClure?
Mr. Hearing Examiner, I have nothing further for this case.
All right, so Ms. Vance, let me see if I understand the discussion went on between you and Mr. McClure. You have to conduct new notice for the acreage that was not included in the original application. Is that correct?
That's correct.
All right, and this is something that the division has given you the option to do instead of dismissing this case and having you refile a new case.
That's correct.
All right. And I just wanted you to know that we went down this route as a courtesy to you and your client.
Thank you.
Okay. So will you be ready for November 13th?
We will.
Okay, very good. So then you will continue this matter to November 13th. You will file a new amended hearing packet with a cover letter. Freya will remove any old documents that need to be removed, and we'll move forward on this case November 13th.
Thank you.
All right, we're off the record in this case. All right, I know we skipped some other cases, Freya, so I'm going to go to number 6, XTO Energy. This is 25577.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, XTO Energy, Inc. And
Thanks. And Ms.
do not,
Vance, go ahead.
I don't believe there are any other
Perfect.
people in this case.
That's the information I need. Go right ahead.
Okay, so in case 25577, XTO is actually only seeking to pull the record title owner for purposes of getting approval on the state communitization agreement. So in this case, XTO is seeking to pool that record title owner in a 447.9 acre, more or less, horizontal well spacing unit, which is comprised of the west half of section 25 and the north half of the northwest quarter in lots 1 and 2. And that's the northwest quarter equivalent of irregular section 36, township 26 south, range 29 east, and that's in Eddy County, New Mexico. There are a number of wells that currently are drilled and completed there, which are initially, or the spacing unit is initially dedicated to those wells, which include the Rostraw, Federal Com 25, TAC 36, 131H, 161H, 102H, 103H, which does have an approved NSL, and that NSL is 8092, and then the 123H, 101H, and 122H. We have included a statement from our landman, who is Chad Smith. He has not previously testified before the division, and so we did include his resume. I will also note our geologist, Mr. Matthew Kearney, he previously submitted his resume, and I talked with you about this, Mr. Shakalian, and you said to just make a note on the record when I presented this case. We previously submitted his resume, but his resume was not reviewed. So, has he been tendered? Not completely. So, but he should be available for questions.
Okay.
With Mr. Smith's statement, we did include the required sub-exhibits for purposes of pooling a record title. And then for our geologist, we did include all the standard sub-exhibits for geology. Along with that, and lastly, is my self-affirmed statement of notice with a sample copy of the letter that was timely mailed on August 22nd, 2025, and then an affidavit of notice of publication that was timely published on August 26, 2025. And unless there are any questions, I would ask that the case be, that the exhibits and sub-exhibits be admitted into the record and that the case be taken under advisement at this time.
Without objection, Mr. Fordyce, questions? You're muted, sir.
I didn't have any questions for this case, Mr. Hearing Examiner. It can be taken under advisement.
Excellent. Okay, we're off the record in this case. Thank you, Ms. Vance. Let's move on to number 7, Matador Production Company. It looks like there's 2 cases, 25581 and 82. Entries?
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Toro LLC. Again, it's Matador Production Company.
Mr. Examiner Dana Hardy with Hardy McLean on behalf of PBEX. And we have no objections and are just monitoring.
Perfect. Thank you.
So in these 2 cases, it involves lands all in Township 26 South, Range 36 East, and that's in Lee County, New Mexico. Both of these involve the Wolf Camp. It's a long Wildcat Wolf Camp pool name, but the pool code is 98234. In case number 25581, Matador MRC is seeking to pool the uncommitted interest in a 553.55 acre, more or less, horizontal well spacing unit. And that is underlying the east half, the west half of sections 14, 23, and 26. And then northeast quarter of the northwest quarter in lot 3, which is the east half of the northwest quarter equivalent of irregular section 35, and initially dedicate that spacing unit to the Kyle Pipkin Statecom 202H. And then in case number 25582, MRC seeks to pool the uncommitted interest in a 553.55 acre, more or less, horizontal well spacing unit underlying the west half of the east half of sections 14, 23, and 26. And initially, and the northwest quarter of the northeast quarter and lot 2, which is the west half of the northeast quarter equivalent of irregular section 35, and initially dedicate that spacing unit to the Kyle Pipkin Statecom 203H. In each of the hearing packets, we've included a copy of the application, the completed compulsory pooling checklist, along with the statements of landman Addison Costley and Blake Herber is our geologist, both of whom have previously testified, and their credentials have been accepted as a matter of record. For both land and geology, we've included the standard sub-exhibits. And then following that is my self-affirmed statement of notice with a sample copy of the notice that was timely mailed out on September 19th, 2025. And then an affidavit of notice of publication that was timely published on September 23rd, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Without objection, Mr. McClure?
Mr. Examiner, I have a quick question for the landman in these cases.
Is that Mr. Costley?
Correct.
Let's get him on the
Yes.
screen.
Yes, I'm here.
Well, I can't see you yet.
Okay.
There you go. I see you now. Mr. Costley, please raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Great. You can lower your hand. Please spell your name.
Addison Costley, Addison, Costley, Costley.
Okay. And you are an expert before this division in what field?
Petroleum land management.
Perfect. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Costley, please remind me what the status is of Matador's interest in these cases.
Yes, so we previously heard both of these cases. The request was the legal description had a scrivener's error previously. That has since been corrected and notice has been resent. The status of Matador's interest is similar to a previous case we heard. It's currently held in Ameredev, New Mexico, LLC, which MRC Toro is the surviving entity of that acquisition. And so that assignment is pending with the state land office right now. From Ameredev, New Mexico to MRC Toro.
Okay, so then currently it's still that same status as it was a month ago then, is that correct?
Correct, yes, sir.
Now, if I recall, did you have something in writing from the state land office in regards to this or not?
Not that I have in the packet. We did submit the assignment of entity, which we can provide if he requests it. So
And the
it's
assignment of,
basically a name change. The entity is survived by MRC Toro. The entity Ameredev New Mexico no longer exists. It kind of just got absorbed into this new entity. So
okay, so then this is similar to like successing operator change type situation. Is that accurate to say?
yes, sir.
Okay, and then that paperwork is just currently before the state land office awaiting their approval. Is that correct?
Correct. Yes, sir.
Okay, thank you, Mr. Costley. I have no further questions, Mr. Hearing Examiner.
Thank you. Can the case be taken under advisement?
Yes, it can.
All right, thank you. We're off the record in these cases. Let's move on to the next case on our docket. That would be number 9. It looks like it's also an Oxy USA case, 25597 and 98.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Oxy USA Inc. And this should be combined with number 10 on the docket. You just called 9, but these are consolidated cases.
Ms. Vance, I called 2 cases. I called 25597 and 98. Thank you very much. Do we have another entry?
You're welcome.
Yes. Beth Ryan on behalf of ConocoPhillips, and we're just entering appearance. We don't have any objection.
Perfect. Thank you, Ms. Ryan. Go right ahead, Ms. Vance.
Thank you. So this is another one where the applicant is just pulling record title. And this involves the acreage all in Township 21 South, Range 32 East, and that's in Lee County, New Mexico. This is the Bone Spring, and the pool is the Bilbrey Basin, and the pool code is 5695. So in case number 25597, Oxy is pulling this record title owner in a 1,002.32 acre, more or less horizontal well spacing unit comprised of lots 1 through 4, and the east half, the west half, which would be the west half equivalent of irregular sections 19, 30, and 31, and initially dedicating this spacing unit to the Regal Lager 3119 Federal Com 1H, 21H, 2H, and 22H. And I believe the 1H is the proximity well that allows for the enlarged spacing unit in that case. And then case number 25598, Oxy is seeking to pool the record title owner in a 960 acre, more or less horizontal well spacing unit comprised of the east half of irregular sections 19, 30, and 31, and initially dedicate that spacing unit to the Regal Lager 3119 Federal Com 3H, 23H, 4H, and 24H. And I believe it's the 3H is the proximity well, allowing for the enlarged spacing unit in that case. We have included in each of the hearing packets a copy of the application, the compulsory pooling checklist, along with the statement of landman Courtney Carr and our geologist Jared Roundtree, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. For Ms. Carr, we've included the appropriate sub-exhibits for land for pooling a record title. And then for geology, we included all of the required geology exhibits. And then lastly is my self-affirmed statement of notice with a sample letter that was timely mailed on August 22nd, 2025, and an affidavit of notice of publication that was timely published on August 26, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record, and that these 2 cases be taken under advisement at this time.
Thank you, Ms. Vance. Without objection, is it Mr. Fordyce?
Yes, Mr. Hearing Examiner, it's Mr. Fordyce. And I didn't have any questions for these 2 cases. They could be taken under advisement.
We're off the record in these 2 cases. Let's move on to case let's see now. We did 11 and 12 before while we were waiting for Ms. Vance to get back. So let's go to number 13. This is Mewborn Oil 25630 and 25631.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Mewborn Oil Company.
Excellent.
And good morning, Mr. Examiner. Dina Bennett with Model Scrolling on behalf of Paloma Permian and Paloma Resources. And at this time, we're monitoring only to preserve our rights.
That's perfect. Thank you. Are there any other parties, Ms. Vance, that you know of?
No.
Go right ahead.
So in both of these cases, it involves the lands all in Township 21 South, Range 25 East, and also 21 South, Range 26 East.
Ms.
And
Vance,
that's all
can you hold on? Ms. Vance, I'm sorry. Can you hold on? I'm just reading the notes from the technical examiner after he reviewed these cases. So before you go through presenting the cases, I'd like to call Mr. Fordyce. Mr. Fordyce, can you tell me about the review in these cases and how you think this should proceed?
Yes, Mr. Hearing Examiner. So when I was looking at these cases Friday morning and researching all the pool codes, these two stage front wells actually have APDs assigned to them, which I reviewed. And the pool code is actually Avalon Wolfcamp Gas 71120 with 640 acres assigned to the well. So instead of being an application for a 320 acre oil pool, what we have is what should be a spacing unit comprised of 160 acre tracts, and not a 320 acre spacing, but a 640 acre spacing. So at the end of the day, pretty much all of the land exhibits and so on and so forth are incorrect.
Mr. Hearing Examiner, we do have our landman available. She was just messaging me, and it sounds like there's going to be some sundries submitted for those APDs. And maybe if we can have our landman speak to some of the feedback Mr. Fordyce provided to possibly provide some clarification so we could move forward if that's appropriate.
Yeah, let's do that. So let's get the landman sworn in, and then we'll have Mr. Fordyce ask the questions, because as it's going now, the case, I think, should be dismissed. However, if the landman provides the proper information, maybe it can proceed. I don't know. Okay, who's your landman?
There she is. Her name is Ariana Rodriguez, and she has previously testified before the division.
Perfect. Thank you. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, great. You can put your hand down. Please spell your name.
It's Ariana Rodriguez. It's Ariana Rodriguez, Rodriguez.
Perfect. And you've been qualified by this division as an expert previously?
Yes.
In what field?
Petroleum land management.
Okay. Mr. Fordyce, please go ahead.
Yes, Ms. Rodriguez, apparently you've heard my comments about these wells have APDs assigned to them with a pool code 71120. That's Avalon Wolfcamp Gas. And so it is my understanding that that gas pool needs to be, the spacing unit needs to be comprised of 160 acre tracts. And so instead of having a 320 acre spacing unit, that would result in a 640 acre spacing unit, which and the C102s on the APDs have 640 acres dedicated to them. So there's quite a few discrepancies between what's filed in the exhibits for this case and what I'm seeing on the approved APD.
Yeah, so we, I think our, the guys that submitted the C102s originally, they had them matching the South Half wells that we had an NSP on. We are not doing an NSP on the north half, and so we are looking to submit a sundry to leave them as 320 spacing units for both north half, and south half, north half.
Could you repeat that again? That you're going to submit a sundry for that's going to do what exactly?
So both of them are now listed as an NSP covering the entirety of the north half, and we're going to submit a sundry that splits them, a north half spacing unit for the 711 H well, and then a south half north half spacing unit for the 713 H well.
Okay.
And they won't be, I think we have these as oil wells as well, so we're changing the pool on them as well.
So you're requesting an NSP and a change to the pool code and name?
That, yes, we will submit a sundry for that.
Okay, I'm looking at the C102 on page 13 of 31. And it does not appear that that has been completed with kickoff points and first and last takeoff points and so on and so forth.
Yes, that's something that I can have our guys change.
Okay, I would request that we get amended exhibits for correcting that, and then I will need to have some time to review that and the rest of the information in here, and then come back and revisit this case, I believe, or these two cases.
Mr. Fordyce?
Yes,
Mr.
Mr.
Fordyce, can you hear me?
Yes.
Okay, great. Mr. Fordyce, what I'm going to do is I'm going to recess this case. Actually, these two cases, I'm going to recess them. I believe we can discuss this offline, and then we can bring these cases back. So, Ms. Rodriguez, would you stay available? We may have some more questions for you in a little bit, but we need to talk about this a little bit before we decide how we want to proceed today. Okay?
Yes, sir.
All right, thank you. All right, so Ms. Vance, we're going to go into recess on these two cases and move on the docket, continue down the docket. So let's see, we did 15 before. Let's see, 16 through, yes, okay. I'm now calling cases 256, 43, 45, 46, and 47, Matador Production Company.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Matador Production Company. And
Thank
these
you.
are, sorry.
No, go ahead.
I don't
And these are?
I don't believe that there's any other parties in these cases, and these are just requests for extension.
Okay, very good. Thank you.
So in each of these cases, we've included a copy of the application, the original order, and a statement from the landman, Isaac Evans, who has previously testified before the division. In each of his statements and each of the hearing packets. Sorry, I'm not sure if you can hear my phone going off. But in each of the statements, we've provided a paragraph of good cause, and nothing has changed regarding the pooled parties in these cases. We provided timely notice. There's a sample copy of the notice that went out, which was dated September 19th, 2025, and then a copy of the affidavit of notice of publication that went out on September 26th. that was timely published on September 26, 2025. And unless there are any questions, I would ask that the exhibits be admitted into the record and that these cases be taken under advisement at this time.
All right, thank you, Ms. Vance. So without objection, I believe these are Mr. McClure's. Mr. McClure?
Mr. Examiner, I have no questions for any of these 4 cases.
Fantastic. We're off the record in these cases. They're taken under advisement. So then we went to 20 and 21 before. So now we're going to do Tumblr. These are cases in which we're having a motion hearing. This is 25462, 64, 63, 65, 66, and I believe these are joined with marathon cases 255, 41, and 42. Entries of appearance, please.
Sharon Shaheen on behalf of Tumblr Operating Partners.
Thank you.
Dana Hardy on behalf of Marathon Oil Permian.
Very good. Thank you. So are there any other entries before we get started?
EOG had entered an appearance in this case. Ms. Bradfute, or Mr. Sayer, I believe.
Well, I don't hear them speaking up. Do we have those parties here, or maybe they would like us to proceed without them? All right, so I called this for a status conference motion hearing, however you want to look at it. From my understanding, this is the party's position at this time, and then I'm going to ask the parties to clarify or correct me as I state it. Ms. Shaheen, and Ms. Hardy, we had a deadline of amended exhibits, and that the parties review each other amended exhibits before they submitted them by the deadline. We received a late request to extend that deadline by I don't know, 4 or 5 days. We granted that request. There were no objections to that as far as I knew. Am I correct so far? Okay.
Yes.
All right. So I believe we got Ms. Hardy's exhibits by the extended deadline. Ms. Shaheen, I believe you wanted a second extension to, in other words, clean up your exhibits before you filed them. Is that correct?
Only one exhibit, the supplemental exhibit that had all the emails. I don't know if you've endeavored to take a look at it, but it's 532 pages. Okay. And that's because our production team didn't quite understand the task, and they included every single email and every single chain related to each email. Since then, we've cleaned that up, and what I believe is only 100 pages has the complete thread of each email chain. So that was what we were hoping to provide for you. We've shared it with Ms. Hardy, and I think she'll agree that it's much easier to review that. And if you'd like it, we're happy to file it. If not, I'm planning in my closing statement to direct you to the emails that are pertinent. So either way is fine.
Okay, so basically, from my understanding, there was, Ms. Hardy, you had objected to a second filing. Have you changed your mind at this point?
I had not objected
okay.
to the cleaned up email exhibit.
Okay. What was the last email or something I saw from you? There was something that I needed to address. What was it?
I'm not aware of anything on my side. I had agreed to the cleaned up exhibit. I know Ms. Shaheen did file an objection to our supplemental exhibits that we submitted.
That's what it was. That's what it was. Thank you, Ms. Hardy. That's what I was getting at. Okay. So very good. So there's no objection to Ms. Shaheen's cleaned up amended exhibit packet. Would that be your second amended exhibit packet, Ms. Shaheen?
This would be the first amendment to the supplemental exhibit. We filed separately. We filed our amended exhibit package, and then we filed an amended rebuttal exhibit package, and then we filed the supplemental exhibit separately. So this would be the first amendment to the supplemental exhibit.
I understand perfectly. Before we go to any objections on your part, Ms. Shaheen. Ms. Hardy, have you had a chance to review everything that Ms. Shaheen just said?
Yes.
Okay. And is there any objection to anything that she has filed or wants to file?
No.
Very good. So Freya, would you remove the supplemental exhibit from Ms. Shaheen's cases and accept the amended supplemental exhibit?
I will do so when filed,
Okay.
yes.
All right, wonderful. And Ms. Shaheen, please attach a cover letter to that amended supplemental exhibit. Mr. McClure, do you have any questions about what we've discussed so far?
The only question I have would be for Ms. Shaheen, just for a quick clarification.
Go.
Thank you, Mr. Examiner. Ms. Shaheen, just to confirm, the cleaned up email supplement, you just have it broke out in each separate email chain now, but it still includes each of the individual emails within those chains. Is that correct?
That's my understanding.
Okay, thank you, Ms. Shaheen. Thank you, Mr. Examiner. I have no further questions.
Okay, I'm not sure. I don't understand that answer, Ms. Shaheen. When you say it's your understanding, it's your exhibit, isn't it?
Yes, it is, but I can't say that I have compared both exhibits with respect to each page in the 532 pages. What I can say is that I've reviewed all of the communications between Marathon and, actually, I reviewed all the communications between Marathon and Tumblr, and between Conoco and Tumblr. And I believe they're all in the same exhibit package. But what I will do is I will go back and confirm that before we file.
Great. And please attach a cover letter to explain why you are amending your supplemental exhibit and that Ms. Hardy does not have an objection to it.
Will do.
Okay, very good. So we've dealt with that issue. Now let's deal with your objections to, what are your objections?
Well, I've prepared an argument if you'd like to hear it, or I can briefly tell you what those objections are.
Well, why don't you start out with sort of an overview of your objection, then we can get into the argument.
Okay, so Marathon included 2 new exhibits in its amended exhibit package. That is Exhibit A13, that's filed in both cases, 25541 and 25542 at PDF page 134 and PDF pages 137, 138 respectively. They also filed a new Exhibit B5 in case number 25542, and that is at PDF pages 155 to 158. We object to both of those exhibits and ask that they be struck from the record.
All right, let's go to Ms. Hardy first to see if she agrees that they're new or not, and then we'll hear the argument on it. Maybe we don't have to hear an argument if she agrees with you. Ms. Hardy.
So, Mr. Examiner, these are the exhibits that were requested by Mr. McClure at the conclusion of the hearing. He asked that we provide our corrected AFEs if there were corrections, or a statement explaining why there were no corrections. So Exhibit A13 in both cases is an affidavit from Mr. Miller attaching the supplemental AFEs. They provide a breakdown of the cost, including the original AFEs. They don't change the amounts. So they are amended to some degree, but they are not corrected, I guess is what kind of how I'll describe it. And his supplemental statement just explains that. And then our Exhibit B5 in case 25542 is the geology information that Mr. McClure had requested. He had asked our witness, Mr. Patrick, to provide the parameters and the APIs that he used in determining the high-risk intervals in the bone spring. And so our Exhibit B5 is that information that he compiled that he had used.
All right, let's stop there for a moment. Mr. McClure, you've heard, is that accurate characterization of your requests?
I'll say I don't remember if it was my request or yours, Mr. Hearing Examiner. If I remember correctly, this is the one where they have like their costs not broke out right, or there was something about it was missing something on the completion cost, if I remember. I don't remember what it was, but there was some discussion about that. I don't recall if I asked for it, but you may have also asked for it, Mr. Examiner. I don't recall what was asked for, I guess now.
What about the geology exhibit? I don't remember asking for that.
Oh, no, yes, I apologize. Yeah, the geology exhibit, I believe I asked them to provide me with the API numbers to be included there off the top of my head.
Okay,
Yeah.
let's start with exhibit B5, Miss Shaheen. While we're trying to figure out who asked for the AFEs, what is your objection to Mr. McClure's ask and from Ms. Hardy's providing the geology exhibit?
With respect to Exhibit B5, Mr. McClure asked specifically, as he stated, for API numbers and the parameters that the geologist used to make a quote high risk determination regarding development of the Avalon, the Third Bone Spring Sand, the Third Bone Spring Carb. Mr. McClure specifically asked for, quote, the parameters and the API numbers used by Marathon's geologists to make a high-risk determination of those three different target horizons. But however, what Marathon has done is they've submitted 4 slides purportedly reflecting geological analyses of certain formations by Marathon's geologists. However, instead of providing a list of parameters and API numbers, Marathon filed an entirely new cross-section and 3 additional slides, each containing a well log, numerous extraneous details about the wells which were not requested by the division, 2 maps, and summary conclusions regarding production that are both outside the expertise of the witness and outside the scope of his testimony. And in tendering that exhibit, Marathon went far beyond Mr. McClure's request, and in an effort, frankly, to introduce engineering evidence without an engineering expert. Marathon chose not to offer an expert witness in engineering. It should not be allowed to surreptitiously offer engineering evidence under the guise of its geologists. It's clearly improper. It's contrary to division rules, in particular 19. I'm having to back up in my argument here. 19.15.4.14b, which expressly states, quote, the witness shall be present at the hearing and shall adopt under oath the prepared written testimony subject to cross-examination and motions to strike unless the witness's presence at hearing is waived upon notice to other parties and without objection. It's also contrary to 19.15.4.17a, which states the commission or division examiner shall afford full opportunity to the parties at an adjudicatory hearing before the commission or division examiner to present evidence and to cross-examine witnesses. So Tumblr is prejudiced by this additional information that goes outside of the scope of a geologist's expertise. And I'm sure the hearing examiners are well aware of cases that hold that a party is unduly prejudiced as a matter of law if they don't have an opportunity to cross-examine a witness.
All right, thank you, Ms. Shaheen. Ms. Hardy, before I come to you, Mr. McClure, are you able to look at exhibit B5?
Yeah, I'm trying to bring it up now, actually.
Ms. Hardy said it was, or Ms. Shaheen said it was pages PDF 155 to 158.
I
Right.
can share it if that would be helpful. I
Would
have
it be
it.
helpful, Mr. McClure?
Yes, it would be.
Please, Ms. Hardy.
So this is the first page. And this second page, there are 3 zones that we're addressing. So that's why there are 3 slides, 1 for each of the zones. And you can see the well log. These are the wells with API numbers. This is the map and where the wells are located on each slide.
So Mr. McClure, what I would like to know from you is, number one, does this satisfy what you asked? Number one, does it go beyond what you asked? Number two, and if it does go beyond what you asked for, do you find it useful enough that we would have to come back to hearing to allow cross-examination on it?
I was gonna say, after Ms. Shaheen reminded me of what we were talking about here, I do recall that there was discussion about the target zones that Marathon had deemed as not productive. So I'm sure that's what these are addressing, or I'm assuming that's what they submitted. I'm assuming that's what they submitted it as based upon discussion today, but I'm not sure as I'm prepared to tell you positively if this addresses everything that I had originally asked for.
Mr. McClure, I see a transcript here. I don't know. Ms. Hardy, did you bring this up?
Yes, I did. This
Okay.
is where Mr. McClure asked for the information.
I thought so. Okay. Mr. McClure, do you want to review this? You know, what we could do is this. Why don't we take a break here? Let's take a few minutes. Let's take 5-minute break. Let Mr. McClure read through the transcript, look at the exhibit B5, and answer those 3 questions that I have, because then we have to go to exhibit A13 and basically do the same thing. Mr. McClure, does that work for you?
Yes, it does, Mr. Hearing Examiner.
Does 5 minutes work for you, or do you want more time?
5 minutes should hopefully be
Okay, why
well,
don't we
5
say
minutes
10?
to look at it, and maybe 5 minutes to touch base with yourself might be the best way to go about it.
Okay, all right. Let's take a 10-minute recess here, and we're off the record. So Freya, can you stop recording? Is that possible?
I can't without ending the meeting.
Then, all right, okay. Then I'm going to mute myself. All right, we are back from our 10-minute plus break. Before we go back to the Tumblr cases, contested cases, I want to address, is Miss Vance still with us? I think I see her there. Miss Vance, there, can you come on? There we go. Ms. Vance, I wanted to circle back on the cases that we said we were going to take a break and that we needed to discuss. Mr. Fordyce, what are those case numbers so I can call them again?
25630 and 25631.
Great. And what line numbers are they on our docket?
Those
13 and 14, I think. 13, 14. Does that sound right?
Yeah, 13 and 14.
All right, very good. Ms. Vance, we've discussed these cases, and without giving you legal advice, the discussion has sort of ended with the following possibilities for these two cases. And I'd rather Mr. Fordyce not be involved in this part of the discussion. My take on this is that at this point, these applications are asking for something that cannot be granted at this point. The idea of a sundry, hold on a second, let me finish the whole thought, because some of these terms and concepts are new to me. So if I get them wrong, I might get them wrong. The idea of asking for something and then asking for the sundry to sort of help these get through is not the way to do this. The way to do this is either dismiss these two cases, reapply for using the proper nomenclature that's there now so that the order can be approved, or apply for a nomenclature change, have that hearing, or I don't know if that requires a hearing or not, but have that approved and then have these go through. That's what I understand is the way to do this. What were you going to say?
So I did talk with our landman, and we just want to make sure that we're on the same page of the division with the division. Right. So really what we want is to just understand what pool and pool code are these dedicated to, because initially Mewburn was told one pool and one pool code, and I think there was some confusion about the accuracy or the correctness of that. And we understand that if this is in fact in a gas pool and pool code, that we're going to have to dismiss and refile. So we're completely
hold on
understand.
a second, Ms. Vance. Mr. Fordyce, sure. Can you give her some help here?
You're on mute, Mr. Fordyce.
Yes, let me click some more buttons here. So for case 25630, we have the stage fright 711H. I looked in imaging for that. Under that API number, it's 30015 57262. So it has an approved API, APD under that API number. And if you can pull that APD up in imaging if you wish to, but the pool name has been redlined to Avalon Wolfcamp Gas. The pool code is 71120. It has been assigned a property number, and the dedicated acreage was unchanged at 640 acres.
Okay. And I just want to confirm, I'm not, trying to ask questions, but I do want to confirm that that is in fact the correct pool and pool code for these wells for both the 711 and 713. Is that right? It's
That's
this
correct.
gas pool. The only other thing that I wanted to confirm is it sounded like there was a condition of approval that also included the requirement to get an NSP. But looking at this, if the building blocks are 320 and the spacing is 640, I don't believe an NSP would be required. So I just want clarification on that this would just be standard 640 acre spacing unit comprised of the north half of sections, I think it's 11 and 7. Because it would be.
What I recall, Ms. Vance, when I reviewed
12,
this
I'm
was
sorry.
what I recall when I reviewed this was that the setbacks were already in line for a gas pool. One of them being 660 from the north and the other one, being in line as well. So I think that you could create a 640 acre spacing unit for both of these wells, and an NSP wouldn't be required at that point.
That's my understanding too, and I just wanted to make sure that we were on the same page. So I think that we will, based on the feedback, it sounds like we need to dismiss and then we will refile. I will just go ahead and say this on the record. We're going to refile that application today. And again, this was confusion that we got regarding these pool names and pool codes. These are time sensitive. And if I can work with Ms. Chance to maybe even if to try and figure out getting this one on the November 13th docket, it would be greatly appreciated.
Okay. All right. So we'll expect a motion to dismiss these two cases in the near future. And we will dismiss them, and Ms. Chance will work with you to get them on the November 13th docket.
Thank you very much.
All right. Now, we're off the record in those two cases. Now, we're back on the record to deal with the Tumbler Matador cases. So now, Ms. Shaheen, are you going to turn your camera on? Perfect. There you go. Okay. So Ms. Shaheen, Mr. McClure reviewed the exhibits carefully. He also reviewed part of the transcript, but not the whole transcript. It's his feeling that these exhibits in B5, now we're not talking about A13, B5, do satisfy his request for Ms. Hardy. However, I agree with you that number one, these exhibits have to be admitted by an expert within their scope of expertise, number one. And number two, that you have to be given a chance to cross-examine this witness who is admitting this evidence. So, Ms. Hardy, your take on what I just said?
I think that's fine. And I think our witness would be happy to testify about the exhibits and that they are within his expertise.
Okay, when you say, which expert are you talking about now?
Our geologist, Tyler
Okay.
Patrick.
Okay, fine. So we don't need you're saying we don't need a reservoir engineer or okay, all right, very good.
Right.
Okay, so let's talk for a moment. So Ms. Shaheen, does that answer your objection?
Well, I mean, we object to reopening the hearing at this state of the proceeding. If the directive from Mr. McClure was limited, Marathon supplemental info should likely be limited. This plays into the reason why we're here, and that is because Marathon has delayed drilling these wells for years. It received pooling orders over 2 years ago. Those expired in May after they got an extension, and yet they still don't want to drill it for another 18 months. And to allow the record to just continue to be open is procedurally unfair to Tumbler. The reason Tumbler is here is because we think these wells should be drilled immediately in the immediate future and not a year and a half down the road. So it just, in my opinion, it's allowing the record to continue to be open is unreasonable and prejudicial to Tumbler.
I understand. Now, Ms. Shaheen, if Mr. McClure had not reviewed the exhibits and come to a determination that this is what he asked for, I would not let them in. I would tell Ms. Hardy to reduce the scope of the exhibits. However, these do answer Mr. McClure's asks, and they don't go beyond his ask. And so with that in mind, I do want to be procedurally fair to you and allow you to cross-examine and your witness maybe to have a rebut. You might even have a rebuttal to
Absolutely.
that. I don't know, but I'm trying, the administrative hearing process is an inclusive process. It's not an exclusive process the way a criminal or a civil trial is. So with that in mind, and I'm trying to give both sides a fair and full opportunity to present their cases. I'm not talking about kicking this down the road a month or two. I'm talking about very short, very, very short. So, Ms. Hardy, when would you be able to have your witness available?
Well, he is available now on this hearing.
Okay.
But
I'm
I
not going to ask
understand.
Ms. Shaheen to
Yeah.
cross-examine him today.
I need to check with him about his availability.
Okay. Hold on. Let's get him on the screen. Can you call his name?
Sure. It is Tyler Patrick.
Very good. Mr. Patrick?
Yes, sir.
Excellent. Mr. Patrick, would you and Ms. Shaheen have a discussion right now about when she would be available to cross-examine you and that you would be available for that on the record?
Yes, sir.
Ms. Shaheen?
Thank you, Mr. Examiner. And I will also need to check with my client as
Of
to when
course.
they'll be available.
Of course, I hear you.
Okay. So my schedule is that I am out from the 23rd through the 30th of October. Then back in the office on, I believe, the 31st. And
Are you
then
suggesting, I was thinking, so you're suggesting you don't have time to cross-examine him before the 23rd?
before the 23rd, well, that would mean later this week or first part of next week. Is that what
Right.
you're suggesting?
I am, yes. Mhm.
Okay. I could do it within the next week. I believe
Okay.
Miss Hardy may be unavailable during some of that period of time, but again, I would need to confer with my client and
Okay.
compare.
Perfect. Why don't we do this? I have an idea. Why don't you communicate with your witness, with your client, their witness, and Miss Hardy, and please come up with, we're not talking about a whole day here. We're talking about potentially this witness and maybe a rebuttal witness from Miss Shaheen. I don't know. So we're talking about a few hours here. So please discuss it amongst yourself. I'll make myself available. I can't speak for Mr. McClure, but I'll make myself available to make it happen by the 21st. I don't want to keep, I agree with you, Ms. Shaheen. I don't want to keep kicking this down the road. We need a decision from the division, but I want to give you your due process.
Understood.
Okay. All right. Now, so we've dealt with B5. So at this point, I'm allowing B5 in the way it is provided and giving you the opportunity to cross-examine and potentially bring a rebuttal witness or submit a rebuttal case based on B5 and any surprise that might give you.
Thank you.
Let's talk now about A13. So I heard your argument before, and Ms. Hardy, I did not give you an opportunity to respond to the argument about A13. Can you tell us why you submitted what you did?
Sure, because the questions asked of Mr. Miller at the hearing focused on whether information was omitted or needed to be changed from the AFEs. And specifically, I think there were suggestions by Tumblr that costs were excluded. So the AFEs that we submitted show that costs were not excluded. the cost on the AFEs we had provided were rolled up into broader categories. So what we have filed, and I can share them, are the AFEs that include the same cost amounts, but break down the categories. So this seems to me that it should be pretty uncontroversial. Mr. Miller's statement explains what he provided. We just thought that would be helpful for the division. I mean, we've got in paragraph 5 here. He's just explaining that the costs from the prior AFEs were rolled up. So that's about it. It doesn't seem to me
All right,
that it should
Mr.
be
McClure,
objectionable.
Mr. McClure, have you had an opportunity to look at this?
Not in a lot of detail, Mr. Hearing Examiner.
Of course not. But I guess my question is, in the same fashion we discussed B5, is A13, does it respond to your asks, or does it go further than what you wanted?
And I would just note for the record that we're not looking at A13 right now. We're looking at, we didn't object to the corrected AFEs. We only objected to the supplemental self-affirmed statement.
Oh, thank you for the clarification. I didn't understand that, Ms. Shaheen. And can you be specific, Ms. Shaheen? What about the supplemental self-affirmed statement are you objecting to?
Well, Mr. McClure didn't ask for any explanation. He just asked for corrected AFEs, which is what they've submitted, and we don't oppose. We're not seeking to exclude those. But there are, I think it's paragraphs 4, 5, and 6 with these kind of gratuitous statements that we don't believe are proper for the record. And again, if they're going to be admitted, I think we need to be able to cross-examine Mr. Miller, I believe it is, on his supplemental self-affirmed statement.
Okay,
and
perfect.
offer rebuttal evidence if it's called for.
Thank you, Ms. Shaheen. Ms. Hardy, how do you feel about that part of the argument now that we know that it's really 4, 5, and 6 that are objected to?
I think that it's really up to the division in terms of whether this is helpful to Mr. McClure and what he had wanted. Because he did say that he wanted corrected AFEs or a statement explaining why they didn't need to be corrected. So it's a little bit of both. So that's why we provided this statement.
All right, so Mr. McClure, will you take a look at, it's on the screen in front of you, page 138, and would you read through, and Ms. Shaheen, it's paragraphs 4, 5, and 6 that offend you?
Yes, you could put it that way.
So I'm putting it. Mr. McClure, would you take a look at paragraphs 4, 5, and 6 and tell me, do you feel those are necessary, or do you feel those go beyond what you asked for and could be stricken?
Yes, I will, Mr. Hearing Examiner. Mr. Hearing Examiner, I wouldn't think we would need 4, 5, and 6, and I think we could strike them.
Ms. Hardy, do you have a problem with removing those 3 paragraphs?
No, I don't. I can do that.
Okay, perfect. Okay, so then, Ms. Shaheen, that is the substance of your objection to A13, is it not?
Yes.
And it's in both.
McClure.
And Ms. Shaheen, it's in both cases, right?
That is correct.
All right. So, Ms. Hardy, that is an easy one. Please remove those 3 paragraphs and resubmit. Why don't you wait before you resubmit anything? I'm not sure what's going to happen when we come back to hearing in the next week or so. There may be other corrections to B5, or I don't know that there will be, but let's just hold off on that correction for now. That's the ruling that I'm issuing based on the objection from Ms. Shaheen and from Mr. McClure's input. And let's do this. Miss Shaheen, how long, and Miss Hardy, how long do you need to negotiate a reopening of this hearing?
A couple days, maybe.
Okay. How about
Depends
close
on-
of business? How about close of business tomorrow on the 15th?
That's fine with me.
All right, perfect. So then by close of business tomorrow, you will email the division with a date and time that your witnesses, I'm going to say witnesses because I don't know what Ms. Shaheen's going to bring, will be available. I'll double check with Mr. McClure. I'll make myself available anytime you need, as long as I'm working that day. And Mondays are not a day I'm in the office, so please don't pick Monday. Don't pick Monday. And that's where we'll leave it. So is there anything further from you, Miss Hardy?
No, thank you.
Very good. Miss Shaheen?
No, thank you.
Very good. When you send the email to Freya, would you also copy me and Dean at the same time?
Yes.
Good.
There is one issue we should discuss, and that is the closing statements. Those are
Right.
currently due on Friday, so that probably should be pushed out.
Very good. That's fine with me. Why don't you discuss that when you're discussing your witnesses' availability, and put that in your email to all of us so we know what works for you. I'm not trying to rush anyone into something that they're not ready for.
Will do.
Okay. I think we are off the record, and I think that concludes today's special docket. So thank you for everyone's participation. Bye-bye.
Bye.
Thank you.